Okay, so I think we are ready for the next session. I believe all of you already had lunch and got ready for the afternoon sessions. This session will also be led by Mr. Paul REICHLER. And Mr. REICHLER, please, floor is yours.
Well, I hope you had a break and an enjoyable lunch, I look forward to hearing some more from you during this afternoon session. I'll do my job. Don't worry, I'm here. I'll do what I have been asked to do. But I would love to see some more participation, particularly when we get to the subject of oral pleadings. And I hope you've had a chance to review Professor Akande's pleading. But what I'm going to cover this afternoon is starting with written pleadings, and then I'm going to go to oral pleadings. And I'm hopefully going to get some contributions from all of you on written pleadings. And from time to time, I'll be asking for questions or comments. But before I do, written pleadings and then oral pleadings, are there any questions that any of you have? Good, from this morning's session. And please identify yourself, even if I know you, please identify yourself for the group when you speak.
Thank you so much. I'm Professor Hajar Girdish. I'm the African Legal Counsel. As I'm taking the floor for the first time, I just need to congratulate and to thank the Japanese government and the partners for this very important international law seminar. I'm really very honored to be one of the participants, especially with you, Professor, and really I appreciate all you are doing. And you said I'm defending the South, and it's important, before I ask the questions, to say that international law, especially the United Nations, was done after World War II, 1945. We are not there. The South is not there. And these principles, as you said, the cardinal principles of international law are now, 8 years after, violated, as you know, and as you said. We are not here to say about the reform of the charter, of the system, because of this unbalanced way, because of these double standards, violation of the principles of international law. At least we have this Court of Justice and other international universal jurisdiction as last resort. But maybe one from the challenges is about the binding decisions. And in the Charter, we have the Article 94.2, who says that the Security Council will be responsible of executing, if not bona fide, if the states in fine does not respect the decision. We've never had the expectation. You raised the Nicaragua case, one of the most landmark decisions as student. For us, it was really very interesting, and it governs all the principles of international law. However, you raised the case of South Africa versus Israel. Even if we are waiting, even if they ask for cease the fire, these are Jus Cogens principles in Gaza 1 year after, and it does not really we have hope. However, it's again about this mechanism, Security Council, the veto right, the 5 states, powerful states who block international law. This is another story. It's about effectivity. Maybe international law, maybe it is sufficient, but the problem is about the international order, political order. If I may just put some questions on the challenges you are raising in the different points before we go to the hearings or the written and the oral statements, based on my own experience, as I was the one who had the position of African Union, and it was in both how to say, this case of the legal, the occupied Palestinian territory, and I represented the African Union position in February, and I have another case, the climate change. I just need to tackle some points very briefly to tell you about our challenges of African countries. Number one, the composition of the team. In general, you said that experts who have knowledge. In Africa, maybe we have knowledge, but we need VIPs or people who have name. So we bring people from the West. We bring professors, experts from the West, well-known, who have names. And I have as the impression that in the ICJ and other international courts, there is a small circle of very VIP people. We do not give the opportunity to Africans, to African lawyers and experts to be in this arena. Maybe this is also a problem that we have to tackle internally. The second point you said about the chemistry between the team, and this is a veritable gap, generation gap between the ones coming as the head of the Minister of Foreign Affairs. Jata, I give some examples from our countries, and the youth. As you said, they can bring a lot of powerful ideas. However, when you have a leader that does not hear about the others, selfish, he just will need to appear in Jazeera, etc., this is a problem, and I like a lot what you said about the chemistry. The point of technicity of the case, when it's coming to climate change, this is the case that we are dealing with,
Right.
and there was an extension in the ICJ till the 15th of August, and we were a little bit upset that only 8 countries from Africa are in the list, in spite of the fact that we've done a lot of capacity building, we've done advertising, communication. However, I feel that, and I asked questions, why African countries does not come in something very important? Right. This is history, climate change, we are victims. So why you are not appearing? They said we lack technicity. So I tell myself, when we are in the universities, we do not have this law of the sea, the question of environment, very highly technical. We do not enough expertise and education here in university, doing master's degree with these different topics of international law is very important. We are not there yet. That's why in ours, for example, I'm not the one who've done the written, statements. We needed expertise from other professors, including Prof. Hilal, Prof. Dapo, Prof. Makan, who will be one of these lecturers here. The technicity also is linked to the financial, human resources and financial issues. I think in Africa and in the South, we have other priorities, so we do not, and this is very expensive, going to these international jurisdictions is very expensive, so maybe we do not have enough money to invest in this technicity, especially when you have annexes, what's climate change or whatever. The expertise needs people who do this proof, as you said, evidence, and this is very expensive. The question of what country to sue, you said something very important. You said, if it is a powerful country, what are your expectations? In the charter, we tell our students 194 states are equal, but they are not at all equal, you may know. So this is also about the question of the violation of cardinal principles of a United Nations Charter. It's about also, yes, we trust in the justice, landmark decision, all the people are really respectful to the huge work of ICJ and other international jurisdictions. However, again, it's a question of violating, not respecting the wall. For example, for Palestine, you saw the wall advisory opinion was never respected, etc. Coming now to the question of the recommendations, maybe capacity building like that. The moot courts for the people who are in the universities. I am coming from Tunisia. We are civil law, Romano-Germanic traditions. We do not have these traditions of practicing law. So our students, after that, lawyers, judges, people going to the ministries, they do not have enough skills in how to build a case. So moot courts competition, and we have more and more, we are involving our students in that. You cannot imagine how it brings expertise and knowledge to our students who will be the leaders for tomorrow. So I think this kind of capacity building, I'm here, I came just to know, to have more knowledge, because I never have this practice. I have the same module, by the way, 10 years in the university. I do not do it like you, because I do not have expertise. I never been in front of the ICJ before I become legal counsel before February. So I go just in theory. Coming like you are giving us the best of your 40 years knowledge, and you give us tricks. You can find nowhere these tricks and this manner and this expertise in books, in doctrine. So capacity building, I think it's very important. The question of communication also. We lack communication. I just try to explain what are the challenges, and maybe also the emergency of the regional mechanism. As in Africa, we have our fusion, the Sharm el-Sheikh Protocol and Malabo Protocol. We will have our Court of Justice. Do you know that after 10 years, where there is only one ratification, so our African mechanism does exist, everything is there. We say African solutions for African problems. When you have these cases you raised between two African countries, why I have to go to The Hague? I have my mechanism. This is also another story, but I appreciate a lot what you are trying to give us as message. In fine, when we are in the content, I'm shocked as jus cogens norms. This is not even when South Africa is going on the basis of Convention Against Genocide. These are jus cogens norms, peremptory norms. And we are even not respecting that. So what else in 2024? It is really shocking for the community, the international community, not also academics, the people who master international law, to see that the minimum, you said about Rohingya, etc., the minimum of international law, REICHLER, human rights are not covered. For instance, Ukraine, Georgia, whatever, the other. So I told myself, all this charter, all these very important principles that we are facing, when coming to the reality, 8 years after, is it time to change the order, to change the different provisions, or to change methodology, or to put more equality and justice? And maybe the South, that's why we are here representing the South. We are coming. It's very important to have this common position for the South and to see the things differently. It is important, again, to trust the international law, international jurisdictions. However, maybe we have to cover the rules. The rules of the game does not change. The context changed. We are facing non-state actors, too much things that are not covered by international law. We are interpreting. The judges are all the time interpreting. So I think there is a lot to be done, but at least I'm really very happy and honored to hear from you. You give us a lot of information that you will never see anywhere. Thank you so much, and sorry to be a little bit long.
One of the tasks I've been given by our friends in the Ministry of Foreign Affairs is to recommend speakers for the third Tokyo International Law Seminar, which will be held next August. And I already have identified the first person who I'm going to recommend to be a speaker next year. There's so much richness in so many of the things that you've said that that would inspire and deserve lengthy discussion. I'm going to reserve until my concluding remarks a response to what you've said about the problems that we face in enforcing, in actually taking these rules and applying them and having them complied with. How do we make the international legal order more effective? I'll share some thoughts with you in my concluding remarks. But one thing I will respond to now, because it does relate directly to a theme we covered in the first part, is building the legal team. I am a fervent believer that let's say, transfer of technology, we used to call it. That is, those of us who've been privileged, fortunate, blessed, if you will, to have years of experience litigating in these international fora, I think we have an obligation to pass on our knowledge and experience to the clients, to the lawyers in the client states that we represent, and more than that, to give them an opportunity to appear in the court and gain the experience directly. I think it is an advantage to have at least one experienced international litigator on the team. But this has been, if you look at the list of who spends the most time before the court, you'll find that not all, but the vast majority are white, male, and from Western Europe or North America. And I confess to being guilty of all of those features. And it has favored my ascent, I have to say, in the profession. I recognize that. So how do I make up for that? Or what do I do about it? Is I have to be an agent for change. We have to open the doors to the wide diversity of talent that exists in the world. Diversity of gender, of race, of color, of nationality. We have to give opportunities to people to develop and to show their talent. And I will say that there are many of us who feel this way. I think most of the judges, if not all of the judges, feel this way. We hear from the judges, those of us who are frequently before the court. When we see the judges informally in conferences or seminars, they'll tell us, we enjoy hearing from you, but we want to hear from others. We need to diversify, just as the court is now truly diverse. We need to diversify the council. We want to hear from more women, more people from Africa, from Asia, from Latin America. I think that's a great thing, and I think those of us who have a say in how these teams are built, we need to put our principles into action. They can't just be words. We have to encourage this every opportunity we have. So I believe in that thoroughly, and it's not just because it's the right thing to do, but tactically it's the smart thing to do. If the judges want to hear from a diverse team, then you should give them a diverse team to speak to them. And this I think is something that many of us are more conscious of, and we're attempting to create, as is our responsibility, opportunities for younger and lawyers from different parts of the world to speak. And I will say, again, I say this only because I mean it, that you are an example of this. You did a brilliant job speaking on behalf of the African Union on the final day of the oral hearings in the Palestine case. And I actually was planning to say that anyway, because I'm going to ask you for help when it comes to the art of the oral pleadings. So but is there anybody else who has a comment or a question or a comment on Ms. Geldich's comment? Yes, sir.
Athir Saidi from the Ministry of Foreign Affairs of Iraq. Thank you for your presentation and the opening remarks by the Minister of Foreign Affairs and officials, organizers from the Ministry of Foreign Affairs of Japan. The rule of law, almost mentioned in every opening remarks, even yours. Don't you think that those who participate and help in created and established rule of law is working to undermining and weakening it? And I need your comment on this. Second question, you mentioned that it's good to review treaties. And what about those states who are not ratified to the Rome Statute, this example, treaty that created the ICG? And with all the influence they have, how we can sue them? I mean, thank you.
Well, I'm going to go off script here a little bit. Given we've had two questions on that are two comments, two very, very, I think, important comments on the issue of compliance with the rules of international law. I was intending to address this in my concluding remarks. I'm going to give some, I can't resist a partial response to both of you now. It'll be partial, and it may mean I have to cut short on some of the other things I was going to tell you about litigation tactics in order to allow you the wonderful opportunity to hear from Judge Donahue after I speak. I don't want to cut into her time. But let me say, sometimes practicing in, I mean, why do I do this? Why have I devoted my career, basically my life, to practicing public international law? You know, maybe you consider me naive, but I do this because I believe in the rule of law, and I believe that what little I as an individual can contribute, what little all of us as individuals can contribute, is important. It's essential. It is the only way we will improve the situation, is if thousands, tens of thousands of us manifest our commitment to the rule of law, particularly those of us who practice and who represent states who are responsible for the legal affairs of states. It's up to all of us. We have different roles: judges, lawyers, professors, government officials. What is the alternative? The alternative is to let things continue the way they are, or perhaps get worse. That's unthinkable. You know, I try to tell myself that the nobility of one's life is not necessarily in the victory, it's in the struggle. It's in dedicating yourself to the struggle of what you know to be right, to be promoting law, to be promoting peace, to be promoting human rights. And it may be very ambitious, it may be overly ambitious, but it's the best we can do, and it's the way for me to live a life that I can try to make meaningful. Now, frustration is inevitable. Sometimes it feels like Sisyphus. You spend years bringing the rock up to the top of the hill, as in the South China Sea arbitration, and then it comes down again and you have to push it up again. But I do believe that in the possibility of progress. And I think despite all the setbacks, which both of you have identified, all of the setbacks and all of the obstacles, that progress is possible, and progress very slowly, not fast enough, not enough, is being made. I think both of you have made the point that those who, let's say, helped most to establish the international legal order at the conclusion of the Second World War, one, were not representative of the vast majority of humanity. And like God, created the order in their own image, and perhaps pretended to be gods, and may still pretend to be gods. Clearly there had to be change. There had to be evolution. There had to be a widening of the rules, influenced by, with input from that part of humanity that was not represented in the establishment of the rules in the first place. And I think while the progress has not been anywhere near fully satisfactory, I think we would be overly cynical to say that there has been no progress. We look today at a particular debate. In the United States, our officials are confounded by the fact that something far less than the entire world is supporting the position of the United States against Russia's invasion of Ukraine. To some of us, and I would say this is certainly my view, this is a clear, dramatic, indisputable violation of the most fundamental principles of international law, the respect for state sovereignty, the prohibition on using armed force to invade, occupy, and annex the territory of another state. Why is it that the whole world doesn't support the position of the US, EU, UK, etc., and others, Japan included? Why is there so much reluctance in the global South? Well, part of this, I think, is because there is a little bit of a distance, and perhaps appropriately so, that states in the global South take in looking at the international order created by those who created it in the aftermath of World War II. There's an assessment being made, are these rules, which we did not make or contribute to in 1945, are these rules that now, in the 21st century, we're prepared to accept? We don't reject them simply because others made them, but we have to assess independently whether we consider that these are appropriate rules. I think Article 2.4 is certainly one of them. That's my opinion, and you probably do as well. Second is, when it comes to applying the rules, are we applying them disinterestedly? Or are we applying them selectively? And if there is a selective application of the rules, do we want to be part of that discrimination? Now, my opinion is, independently of all of these legitimate considerations, a violation of Article 2.4 is a violation of Article 2.4. It has to be condemned. But the same powers that are so outspoken, and appropriately so, about the invasion of Ukraine, invasion, occupation, annexation of parts of another sovereign state, are, at least to this point, still supporting the United Kingdom's colonial enterprise in the Chagos Archipelago, which belongs to Mauritius. The International Court of Justice said this is sovereign territory of Mauritius, and the United Kingdom must end its unlawful administration as rapidly as possible. That was in 2019. Now, I will say that Mauritius, which I represent, and the United Kingdom are engaged in serious talks on ending this state of illegality. But the fact is, it shouldn't require talks. The world's highest legal authority has decided that this is an illegal presence that must be ended as rapidly as possible. The General Assembly, in an implementing resolution, said 6 months is the time limit for ending it, though it's now been 5 years. The same is true with Israel and Palestine. As the ICJ has just confirmed by overwhelming majority and some of the strongest language we're likely to see in any advisory opinion. Israel's 57-year-old occupation, annexation, and settlement of the Palestinian territory is illegal, and it must be brought to a conclusion as rapidly as possible. Here, not only the United States, not only the United Kingdom, but many states, and particularly the European Union, we're talking about many of the states that were the authors, the creators, at the genesis of the modern international legal order in 1945. How can they have such a double standard? So I think if we who believe in the rules believe in Article 2.4, we can't have a double standard if we want the rest of the world to join us in enforcing these rules, in holding these rules as a standard for everybody. I'm a little off topic here, but as I said, I'm here to respond to your concerns and questions. So, and I couldn't resist. So, forgive me if it sounded like a sermon, but there you have it. Yes, sir.
Thank you, sir, for the lecture. My name is Kiran Mohan, and I work for Asian African Legal Consultative Organization. In the morning session, you spoke about how international tribunals, especially ICJ, are somewhat skeptical about considering layperson witnesses. Zooming out a bit, how are evidences treated in these courts, especially when it comes to standard of proof in different types of cases? What are your personal experiences on that front? Have you faced challenges with regard to the lack of one common standard that tribunals like ICJ and its laws consider? Does it need some sort of standardization?
Let me say, I think that if you look at the jurisprudence of the ICJ in particular, now, when many people read the cases, they're looking for the legal principles, the rulings, the judgments, and that's as it should be. But for those of us who are practitioners, we look at those aspects, but we also study very carefully what the court has said about the use of different kinds of evidence and what kind of evidence the court regards as the most probative. And just like you can discern the law from reading the cases, the precedents, you can discern the standards that the ICJ regularly applies in receiving, evaluating, and weighing evidence from reading how it addresses these issues in an entire series of cases. And we can go back to the Corfu Channel case, but the Nicaragua case is one. Of course, people remember it for the ruling and for the, in a sense, the breakthrough of a small state triumphing before the court over the most powerful country in the world, and how the court showed that the court provides an equal level playing field for states large and small, powerful and not. But the case is rich in teaching us how evidence is received, evaluated, weighed, and applied. And I mean, it's beyond the scope here, and I don't have all the cases listed in front of me, but it's no mystery. By examining the court's rulings, you can discern how the court receives and evaluates evidence. And really what is within the scope of what I am saying is when I, in the morning session, when I related the kinds of evidence that are most compelling in filling out your narrative, in making your story, I was relying on what I have learned from my own practice, but also reading what the ICJ has said in its various cases on the use of evidence and the value of certain kinds of evidence. And that's why I emphasized contemporaneous official documentation, or contemporaneous documentation from other reliable, authentic sources, or statements against interest made by, or what we call admissions, made by a state that can be used against it, or the authoritative expert reports of independent, reliable United Nations bodies, and so on. So we do know what the court is likely to give the most weight to. And when I said that live witness testimony does not rank among the most important kinds of evidence that the court will consider. I tried to explain why I thought that was the case. And again, a lot of it depends, a lot of it is attributable to the fact that the judges come from different legal systems, which is inevitable on an international court that is truly an international court. And the value of live witness testimony, especially when examined or cross-examined by partisan counsel in front of the court, is viewed very, very differently by judges from many parts of the world than it is by judges who have a common law legal education or background. So it is, I think the court has given us great guidance on what it takes to convince it. Yes, sir. My friend from Saudi Arabia.
Hello? Yeah. This is Abdurrahman Sheikh from Saudi Arabia. In the morning session, you mentioned something related to the jurisdiction, or how to build the jurisdiction, and it is very important starting point to start the litigation. Now, we are all aware that some countries actually, they do have reservations on the jurisdiction of the ICJ and maybe other international courts, and they prefer to do this through particularly going to arbitration. Now they end up sometimes actually drafting a very poor arbitration clause that will easily end up with a deadlock. So in a commercial actually perspective, that can be sought in many ways. But how this can be sought out from public international law, if you have a deadlock, you have arbitration and you have reservations on the international court's jurisdiction.
I'm very glad you raised this issue. It's a very important one. And I think the short answer, and then I'll elaborate, is it's very important to have expert legal advice, whether it's from within your own country or outside is for you to decide, on the drafting of an arbitration clause, whether it's a separate arbitration agreement, a standalone agreement, or it's part of a broader agreement on substantive issues. I'm very familiar with the problem you raise. I've seen it in a number of contexts. There will be an agreement to arbitrate certain kinds of disputes, and then it will provide for how the tribunal, the arbitral tribunal, is to be composed. Sometimes one state appoints 2 arbitrators, the other state then is supposed to appoint 2 arbitrators, and then the 4 are supposed to get together to choose the 5th or presiding arbitrator. And I've seen versions of this where the party-appointed arbitrators are unable to agree. The decision on appointing the 5th member will be referred to a 3rd state, which shall then designate the president of the tribunal. There are variations of this. The problems arise when, one state initiates arbitration, it appoints its 2 arbitrators, the respondent state doesn't respond. It never appoints the arbitrators. What happens? There's no agreement, there's no possibility of agreeing on the 5th arbitrator. Sometimes the 3rd state, which is the so-called appointing authority, hasn't been designated or it hasn't agreed to play this role. And even if those boxes are checked, how is it supposed to appoint an arbitrator, a presiding arbitrator, if the respondent state is not participating. So these things have happened. This is not theoretical. And what the result is, there's no arbitration. So the arbitration clause is useless, and the attempt to arbitrate is frustrated. This is why great care has to be taken in negotiating the arbitration agreement to provide, as you see, the PCA has rules. ICSID, which is not state versus state, but state versus investor, has rules for what happens if the respondent state does not appoint an arbitrator or if the parties are unable to agree. There's always an appointing authority in order to make sure that the arbitral tribunal is fully appointed, fully functional, and most of the arbitral rules for these arbitral bodies provide that the failure of the respondent to appear does not prevent the tribunal from going forward. We have the same rule basically in the ICJ. If the ICJ refuses to appear, it does not stop the court, provided it has jurisdiction, from proceeding with the case, although, as is the case in many of these bodies of arbitral rules, it has to take special care to ascertain as best it can the legal and factual positions of the respondent state in the interests of fairness. It becomes a difficult challenge when the respondent state is not there to defend itself, but nevertheless, this is part of the obligation. This happened with the United States in the Nicaragua case at the merits phase. The United States appeared to oppose provisional measures, to oppose jurisdiction, but it opted out of participating in the merits phase. The court proceeded as best it could from the public record and from records, from documents that the United States had submitted to ascertain the position of the United States, and it rendered its judgment. Arbitrators can do the same thing, and this is also part of Annex 7, the arbitral rules under the UNCLOS Convention. But you raise a very serious and real problem, and the solution can only be in the drafting of the arbitration agreement, and that has to be by mutual agreement. Without agreement, there's no arbitration. Okay, I'm on this side. I'll come to you in a moment. Yes, sir.
Hi, my name is Tomoki Yanagisawa. I'm a litigator from here in Japan, and I practice litigation arbitration. And thank you for your lecture this morning. I was very interested in when you discuss all these litigation tactics and strategies because they resonated very much with what I do every day. So I was very curious to know what is the most salient difference when you practice litigation based on public international law as opposed to any private law or other commercial disputes. Thank you.
Am I allowed to detract you a little bit? Sorry? Am I allowed to distract you rather? Okay, thank you very much for your presentation. This is Adil. I'm a director from the Ministry of Foreign Affairs, Government of Pakistan. I'd first like to thank the Ministry of Foreign Affairs of Japan for having us here and for this very intellectually stimulating seminar. I'd also like to thank all the distinguished delegates from the African Union, ROC, and South Africa, and others who have made their interventions before me. Now, sir, you mentioned just a while ago that some of the developing countries have a difficulty in understanding that the actions of Russia are actually a violation of Article 2.4. The UNGA, since then, has passed a number of resolutions, and I'll just give you statistics. So the last such resolution, which was passed on the eve of 1 year invasion of Russia, Ukraine's invasion, was passed by a vote of, I believe, 137 votes in favor, 40 votes neutral, and I believe 4 votes against it. And if you contrast this with what's happened in Palestine, for instance, it took, I believe, 7 special sessions of the United Nations Security Council just to add the language in the draft resolution that there should be access of humanitarian aid to the people of Gaza and the people of Palestine. So those are just the facts, I mean, of course. Now we're talking about the significance of international law. I come from a country where international law and its significance is actually staring us in the face. And the fact that there is no rule-based order at this point in time in many several ways. Now, I was part of the exercise that actually happened when we were drafting this advisory opinion on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory. We also made oral submissions. Government of Pakistan also made oral submissions. The ICJ's judgment is as clear as day and night, as you said yourself. We also saw the fate of that ICJ's judgment, and we are continuing to witness what's happening in Palestine, what's happening in Gaza, despite a very clear judgment by the highest court in the world. Now, just to narrate a simple story of how international law interplays with what's happening in my country. In 1990s, Pakistan contracted with a company under Pakistan-Australia Bilateral Investment Treaty, and we contracted that a mining facility would be handed over to that company. In 2000s, I believe it was 2014, a court of Pakistan decided that the contract had been awarded to that particular company in violation of the local laws. Some local laws, and in particular that the company officials had been involved in bribing and corrupting the officials of the government of Pakistan in getting that contract. Fast forward to 2018, the famous Techian case took place. Techian case, for some of you who may not know, was an arbitral award against the government of Pakistan by the International Center of Settlement of Investment Disputes, ICSID, to the tune of $5.6 billion. Now, if we look at these numbers in isolation, these are just numbers. But let me give you a perspective and the context of these numbers. $5.6 billion is much more, is actually thrice the amount that Pakistan can and actually invests on its health and education annually. In 2020, Pakistan went to the IMF for a bailout package of about $6 billion, whereby the IMF was supposed to give us $6 billion over a course of the next 5 years. So that's what $5 billion really means for countries like Pakistan. Now, as you said yourself, sir, arbitral tribunals are, okay, let me take a step back. In 1947, when Pakistan was created, there was an English judge. For no fault of his own, he landed in South Asia, in the subcontinent, and he was given a very difficult task by the British. He was told to divide the borders of the undivided subcontinent. Someone asked him, how well you know this region? And he said, I have absolutely no idea. This is my first time. And the judge, for him not to be corrupted or influenced by what was happening in the politics of the day, he was given a room, an isolated room, I would say, and he was given a scalpel. And he was told, you're supposed to divide the frontiers of India and Pakistan. And what has happened since then, we have a long-standing dispute with one of our biggest neighbors, and the dispute continues after more than 7 decades. So if you put in judges who are not familiar with what's happening in a country, I mean, the distinguished delegate from African Union raised all the valid points, that if you have judges who may not be familiar with the language, with culture, with history, with the type of investment in a country, they would have awards like that. It is the second largest award against any sovereign country after the UCOS award of $30 billion against Russia, the Techian case against Pakistan. So what I'm saying is, I love international law. Not as many years as you have, sir. I hope to one day, but it's been more than a decade for me working in the National Legal Division of the Ministry of Foreign Affairs. I've held assignments abroad. I've tried to, talk about these issues as a diplomat, and of course, a diplomat who's trained in law. But increasingly, international law cannot just function in isolation. It has to be underpinned by international relations, right? It has to be underpinned, it is underpinned to a great extent by the geopolitics that dominates us, that is around us. So for a lot of countries, developing countries like Pakistan, many other developing countries, we were the chair of G77 and we passed many resolutions which are underpinned by great intentions. But then what is the outcome here? Where do we find ourselves today? Where does humanity find itself today? What's happening in Gaza, South Africa? I'd like to congratulate you. This is an amazing moral position that South Africa has taken, showing the world. What happened in Nicaragua versus the United States? What's happened in so many other cases where the ICJ has been... I don't have a question, sir, but my question is, how does it keep you going? 10 years in international law, and sometimes it's a source of great frustration. You could have the nuts and bolts of law very clearly out there. You have a judgment backing you up by the highest court in the world, and still you have people who are starving, millions and millions of people who have been driven out from their homes and starving. And from what I see, there's not much light at the end of the tunnel. I'm sorry for my very long intervention, but I thank you very much, sir, for your patience.
Well, thank you very much for that. There is, again, so much of value in so many things that you have said that it would take far in excess of the time available to me to engage on every issue. I'll just make a couple of quick comments. One, I think you did a brilliant job of illustrating the double standard that has been applied. The United Nations General Assembly resolution on the invasion of Ukraine, overwhelming support, and yet the difficulty because of the obstinacy of certain states or a certain state in getting a resolution from the Security Council, even on a humanitarian access to the Palestinian people in Gaza. The double standard exists, and it is an obstacle to the universal acclaim, acceptance, enforcement of international law. What can we do in a world where power, an extraordinary power, resides in certain states? Power is not shared equally. Yes, everybody has a vote, a same one vote in the General Assembly, but because of the way the United Nations is structured, and even outside the United Nations context, there are superpowers who influence whether international law is enforced and applied or not. This is the world we live in. How do we confront it? I know it's a source of great frustration to you. You've spoken very eloquently about it. I mean, in my humble position, it's a source of great frustration to me. I think we can, one solution, which you're not suggesting, is we just give up and we just say power will rule. But that's not who we are. We're going to keep trying, we're going to keep fighting, we're going to keep working, and maybe inch by inch or centimeter by centimeter, we're going to make whatever progress we can. And I think that as I said before, I think we compare ourselves to 10 years ago, 30 years ago, 50 years ago, 80 years ago, and I think even a cynical person would have to admit or a skeptical person that there has been progress. At least we are able to call attention to these violations, to unite our voices in condemnation, and to try to influence behavior through the pressure of a united international community. There's no question that international law cannot be seen devoid of its context of international relations and power relations among the states of the world. That's the context in which we all function. And it's what we do. It's the obstacle. It's the challenge. But the only thing we can do is keep working, keep trying to unite, keep trying to assemble coalitions of states within the international community to bring about pressure to cause a greater compliance. You know, I think that I have talked about this in many contexts, that there exist in the system that we have strong disincentives to defy international courts and their judgments. Even though the ICJ cannot send in a police force or a military force to enforce compliance. We have some blatant cases of violation, but as I said earlier, the vast majority of states comply with the court's judgments and other international courts' judgments in the vast majority of cases. Why is that? Because it is part of a state's soft power, its diplomatic influence, to be able to present itself to other states as law-abiding, as law-enforcing, as acting in ways that support the international, rules-based international legal order. That may not be the determinative factor in their foreign policy, but it is a factor that has to be taken into account. It was certainly taken into account in the United States after the Nicaragua judgment, not necessarily by the administration, but by the United States Congress, which after the court's judgment cut off all financing, all military support to the military forces that the United States had been supporting to overthrow the government of Nicaragua. There are many ways, there are different ways in which the judgment of the court can be used to influence the behavior of a recalcitrant state. It doesn't always work, but we do the best we can, and we work better when we are unified around the issue of rule of law. And I think that will be ultimately the outcome in Israel and Palestine. The Israeli newspaper Haaretz, which is very critical of the government and its policies, particularly as it relates to Palestinians, but they called the ICJ's advisory opinion a slow-moving earthquake. And I think that that's an apt analogy, and I think it applies to many other situations too. It is an earthquake in its ultimate effect. It's slow-moving because it takes time to gather momentum and support. But the ICJ has set the legal standards. It has declared illegal this occupation, annexation, and settlement. Now it's up to the rest of the world to bring pressure on the recalcitrant state to comply. How do they do that? Well, the UN General Assembly is going to adopt another resolution this fall, like it did after the Chagos advisory opinion, and it's going to spell out the legal consequences for third states of this opinion, just as it did in the Chagos case. And the court, in its advisory opinion, and an extremely important part of this is what it said the legal consequences for other states are. And if other states take these obligations seriously and act collectively, it will bring an enormous amount of pressure on the recalcitrant state in this context, and it will inevitably influence opinion in that state. It may take more time than we would like, but the idea is the isolation that ultimately caused the apartheid regime in South Africa to accept change can have the same effects there. It will take time. There will be an incredibly horrible cost to humanity over this period of time. But it may very well be a slow-moving earthquake. Now, I've enjoyed this exchange very much, and I'm happy to continue it if anyone else has any comments or if you want to comment to each other. I think, honestly, this is more important than what I have to tell you from here. But if we're ready, I can continue. I would like, if you have the patience, to tell you some of my trade secrets about written pleadings and oral pleadings, and then hear some of yours. Okay, I'm going to take a sip of water here. And I want to hear your comments about Professor Akande's speech, but we'll get to that. Let me try to go somewhat efficiently or rapidly through what I'm calling the art of the written pleadings. In fact, for the gentleman of Pakistan who raised some other point, I do want to compliment your law minister for his outstanding presentation, by the way, in the Palestine Advisor. It was one of the best. But I do want to comment about the ICSID proceedings, but perhaps afterwards we can have a private, because I share your, how can I say, disappointment in the ICSID arbitration system. I'm known as a great critic of the system. And I do think the selection of judges and having knowledgeable judges who understand the realities in the states that are affected by their judgments is critically important. And we don't have that in the ICSID investor state dispute settlement. It's one of its big drawbacks. But we can talk about that later, but I'm with you on that. Written pleadings, I think you know that formally most international legal proceedings have 2 rounds of written submissions. The first round is the memorial by the applicant state, the counter memorial by the respondent state, and then there's another round, the reply by the applicant state, the rejoinder by the respondent state. One thing to bear in mind is that 3 of these 4 written pleadings are responsive pleadings. They're responsive to what came before. So my remarks will be more focused on how we craft the most effective responsive pleadings. Let me say that, I've been around a long time, as you can tell, and I've read hundreds of written pleadings. And I can tell you that the quality varies very greatly. Some of them are outstanding, and some of them are rather poor. So because I try to learn every time I read another pleading, not only what's in the pleading, but what can it teach me about my craft? How can I use this, if it's good or bad, to learn something to craft a better pleading myself? So I spent a lot of time thinking about what are the qualities that make a written pleading outstanding. And I'm not going to claim that I achieve this goal in every pleading that I write, but I certainly try to. And so I'm going to share with you make some observations that I'll share with you on what I've learned. And some of these observations may seem blindingly obvious to you. Others may be more subtle, and it may convey to you some new ways of thinking about these. The first concept is this. You have to know who your audience is. Who are you trying to persuade? And you must write your pleading in a way that is designed to persuade that audience. Of course, the audience is the judges or the arbitrators. Now, this seems rather obvious, but in practice, most of us, I don't mean most of us in this room, I wouldn't speak for you, but most of us who practice, we're really writing to convince ourselves rather than to convince the audience. And what do I mean by this? It's not necessarily conscious or deliberate, but we all have a tendency to assume that what we find convincing about our case will be convincing to the audience who we have to convince. And that's not always the case. This is what I mean by writing to convince ourselves. We have to be able to step outside ourselves, put ourselves in the position of the judges or arbitrators who we're pleading to, and try to visualize, try to perceive how they are receiving the arguments that we are making. Will they find them as convincing as we do? And it's not always the case that they do. First, the judges, or some of the judges, when you have a large panel like the ICJ, they may have different views of the law than you do, or different views of the law than each other. And it's important to try to assess where the court is, how the judges see the law, to appreciate how they might receive your legal arguments. Now, your legal argument is the one you have to make to win the case. You represent a client. But how you frame that argument, how you express it, has to take into account how you think your audience is likely to see it. Again, what may be convincing to you may not be convincing to the majority of judges. And so you have to try to step outside yourself and see your case and your arguments as your audience would. There is another aspect is that, which is almost always the case, the judges will never know the facts as deeply, as thoroughly, as comprehensive as you do. Now, there may be some exceptions on the court, or any court or tribunal. But you will have spent months, if not years, dedicated to developing your case, knowing the facts, knowing all the details. And the judges have to learn them from you and from the other side in a rather short time, reading and mastering what is normally too lengthy, very lengthy written pleadings. So you cannot assume that they will know the facts as well as you do. So when you plead to them and when you argue the case, you have to take that into account. And that requires you to be selective. Too many facts or too many assumptions of what the judges appreciate will take you in the wrong direction. It may overwhelm your audience or fly past them, especially if you haven't developed the right story, logically connected and supported by the evidence. These written pleadings often extend for hundreds of pages. But the key is not the volume or the amount of detail you put in. It's the convincing nature, the compelling nature, the logic, the evidentiary support for the story, for the narrative. And this is where your focus is. I spent some time this morning talking about developing the narrative, the story that is both supported by the evidence but also compelling, easy to read, easy to understand, leading to the right conclusion. This is the heart of the written pleading and the art of making a written pleading. Focus on the essential facts, the essential part of the story. Don't overwhelm the court with too much detail. Obviously, you have to be fairly complete. You don't want to tell part of the story and leave out another part. But too much detail will overwhelm the court. Too many pages will discourage the reading of the brief from the beginning to the end. Stick to the story and the basics and the evidence that supports it. Try to be readable, interesting, and efficient. Now, of course, the most important part, in addition to the legal argument, is the evidence, the key evidence that supports each element of your story. It's important not only to provide, to discuss or address the helpful evidence, the evidence that supports the factual elements in your story narrative, but it's important not to ignore the unhelpful facts. There's a big danger in ignoring or denying facts that are unhelpful, that don't fit into your story, or that may even appear to contradict it. Your credibility is at stake. You can assume, and you should assume, that the judges will find a way to those facts, either on their own or more likely because the other side is going to bring them to the court's attention. That's their job. If you ignore them, you will give the court the impression, one, that you're hiding important facts from them, which undermines your credibility, but also, by ignoring them and having the other side bring them out, you will end up magnifying their impact on the court. So it's important to be thorough in that sense, transparent, and not appear that you're hiding the unhelpful information. Now, also, by bringing it to the court's attention, this doesn't mean that you're making a confession as if you were confessing your sins to a priest. It's the style in which you do this that is important. And by mentioning the unhelpful evidence, first you're showing your honesty, your transparency, your lack of fear of this evidence, and it gives you a chance to characterize it, to contextualize it and explain it, and diminish its effect. I often find that it's helpful when I'm drafting a written pleading, when I'm telling my story in writing, to have a trusted sounding board, usually one of my colleagues on the legal team, and always the client, who obviously is going to read your pleading and sign off on it before it goes in. But it's extremely important that we get this feedback from our colleagues as a reality check. I think this really works. I think this is an absolutely compelling pleading. I think I've told the story in a clear, compelling, readable, easily understandable way, and I think the judges will love it. Maybe, but it's always helpful to get feedback from a trusted source. I find that when a legal team is functioning well, both the client and other colleagues, we're reviewing each other's drafts and we're giving each other honest feedback. Now, to be honest, it's never pleasant to hear criticism of your work, especially when you think this is a masterpiece, and then you find out, well, maybe it doesn't rise to that level. So you, again, as I spoke before, the good chemistry on a legal team means we all listen to each other, we accept criticism gracefully, and we try to reach a consensus that we all feel is appropriate. So you get over the blow to your pride, and you go back to work. And it inevitably improves the quality of what you've done. The best legal writing in a litigation setting aims for clarity and simplicity. If it's clearly written and simply expressed, it's much easier to read, to follow, remember, and enjoy. Clarity requires short sentences, clear language. The goal is actually to take something that might be a bit complicated, but express it as clearly and simply as possible. This is the complete opposite of much of the writing you find in law reviews and other academic journals. I sometimes think that the authors of these articles, they think the goal is to take a relatively simple point and weave different strands around it and make it as complicated sounding as it can be, maybe as a way to show or to show off their intellectual prowess or their expertise. This might or might not pass in academia, but it certainly fails in court. Simplicity is the goal. A simple story or explanation is easier to follow and accept as long as it's accurate and covers all the essentials and is supported by the facts. Now, I've talked about the following so far in brief writing. Know your audience and write what will be convincing to them. Write as clearly and as simply as possible. Find a trusted person or colleague to serve as a sounding board and give you honest feedback. And above all, make it readable. The judges have an enormous amount of reading to do. And if you don't make your brief readable, you can assume that they will stop reading. Unless they feel it's helpful to them to continue reading, why should you expect them to do so? And all your hard work will be wasted. Now, I'm not advocating a no-frills approach to brief writing. You can and should use colorful and interesting language, emphasis where appropriate, and even humor and rhetorical devices like alliteration to make your narrative more interesting, more enjoyable, even more fun to read. But keep the sentences short, the writing clear, and maintain the consistency of the narrative. Keep that narrative flowing. Again, step by step, supported by the evidence, which you refer to prove each point that you're making, but keep it flowing from beginning to end. What I cannot emphasize enough is the importance of being credible. Without exception, you cannot win an argument if you are not credible. Now, what is credibility? Credibility is not only honesty and truthfulness. Of course it is. You have to state the law and the facts accurately. You don't hide or sidestep the unpleasant facts or the unpleasant cases, but that's not enough. Honesty is a necessary condition of credibility, but it's not the only one. You must also be reliable. What good is a truth teller who acts in good faith but makes mistakes? Who is scrupulously honest but gets the facts wrong or presents them incompletely? If you want the judges to trust you and your client, it's necessary but not sufficient to be honest. You must also be reliable in presenting the facts, describing the case law. Again, if they don't consider you credible, if they don't consider you trustworthy, if they don't consider you reliable, why should the judges continue reading what you've written or continue listening to you when you speak? I also want to address structure and organization in talking to you about written pleadings. These are very important. I know a lot of lawyers who just sit down and start drafting. I find that to be a misguided approach. I spend a lot of time thinking about the organizational structure of the pleading to try to make it as logical as possible, one point following the other. I think about back to the days many years ago when I studied geometry. And my model is a geometric proof. It starts with an axiom, a point that is universally accepted or at least unchallenged. And then from there, it adds an element and draws another conclusion at that step, which follows from the first if you add the element. Then it adds another element, which could be a fact or a legal rule, a case. And then that forms a conclusion, which is difficult to debate because it flows from the previous point plus what you have added. And step by step by step until you get to the final conclusion and QED. I think if you think of your legal brief, as a kind of geometric theorem, it will help you in the organization and structure, and it will help make it more persuasive. You start with the point that's commonly accepted. You add a fact that is proven by the evidence, and then that leads to another step, another conclusion. Add again something that is correct because you have the fact or the case law to support it, and keep going step by step. And if you have all of these different points in the right order, it will proceed like a geometric proof, and you end up with QED. I know when I see a brief that is poor, it's almost inevitably because of the structure. It goes back and forwards. It has the wrong points in the wrong order. You may make a point here, but you lose it because of the way all of the arguments are presented, the way the story is told. So organization and structure are extremely important. I find, and I often tell younger lawyers who I counsel, that once you have the right organization and structure, the brief almost writes itself. It's like you have the skeleton, and all you need to do is just put the flesh on the bones, which is your eloquent but simple and clear language connecting each of these steps. And style is important. You can use some literary style or flair or even humor in the process to liven it up. But the bare bones of it, the skeleton, is this organizational structure that proceeds in the form of a logical proof. Always remembering that what you're doing is telling a story, a true story that is supported by the facts and leads to the inevitable conclusion. Now, there is more that I can say, but I do want to spend some time on oral pleadings. And I want to start there with Professor Akande's speech. And I'm going to ask for comments about it. I obviously chose it as a sample for you to read. You can assume I chose it because I think it's very good. In fact, it's outstanding. Why do I think that? What makes it so outstanding? Or if you disagree with me, tell me. Or if you think, well, it may be outstanding but could have been better if he did this or that. He's not here today, so you don't have to worry. And we won't tell him if you criticized his pleading. But does anybody want to start off? I think we have about 15 more minutes. Maybe we can stretch it by another 5 minutes, but maybe we can spend just a few minutes on this, and then I can give you some of my trade secrets on oral pleading. Anybody like to make a comment? Yes.
Hi, I'm Yuichiro from the Ministry of Foreign Affairs of Japan, and just sorry, the cursory reading, but this oral statement is structured exactly what Mr. Reichler said. So it started with a universally accepted definition or case laws, but it goes deep into the point that the other side, which the Professor Akande would like to criticize or point out, and Professor successfully proved that the structure of the other side of the argument, and so it is concise but still strong and very readable and understandable. Thank you.
Good. Anybody else? Yes, sir. You're a litigator, so, well, I'm sorry, there's a lady over here who hasn't spoken yet, so let me call.
Maybe on the form, clear, brief, well-constructed and structured, and on the content, it is based on legal argumentation. Just to compare with the African Union, as we are the last ones after more than 1 week pleadings and more than 55 states and organizations, we had a different strategy. And our strategy was not to repeat what others said. We were very brief on the competence and on the historical and context and the background. And we choose to tackle the argumentation of Great Britain and United States of America. So we added a plus value on the ones that were there. So it's also a strategy, it's a context, it is when you are there. Judges were very tired and exhausted after too many hearings, so it is also, as you said, very important to be brief, and to do that, we completely are different from the written states. We were at last minutes, 4 in the morning, including yourself, so we've done research on all what the other states have done. We bring our students to do summaries and sum up of all the statements so that we do not repeat. Until 4 in the morning, we were on the details, how to make it brief, coherent, to telling story. And it was, for me personally, a very nice exercise. We were a team, and it was practitioners, lawyers, professors, youth, people coming from Africa, but also these students who were able to give us these sum up so that we can go straight to the point, and we tackled other legal points, and we have done it differently if I compare the oral to the written statement. Thank you.
And as I said earlier, the African Union statement, including your presentation, was brilliant. And we can let you know how to access that. And so you can find, and some of the points you made here, that what you took into account in constructing the pleading are very important, and I'm going to mention those myself. Oh. I'm sorry, did you hear me? Anyway, let's have just one more comment from this lady who has a chance, Miss. Yes.
Hi, my name is Nyam Suramukhte. You could call me Toya. I'm from Mongolia, and I am a master's student of Yokohama National University, and thanks to JICA, I am participating in this seminar. And I have a very brief comment on this oral statement of Japan. And what I have found after reading this statement is the conclusion, it itself says the reply of Japan's view about this situation. It reminds the states that there is already the principles which was mutually agreed in 1970s, right. And it says no to states according to the UN Charter that the acquisition of territory by force is not possible. So
Right.
every state should retain to interfere
Right.
the territory. So they have to follow the obligations under the U.S. Charter. That's what my comment. That's all.
That's very good. That's very good, and I thank you for that. I'm going to continue here, and if there are other questions about this, I'll be here during the break if anybody wants to continue talking. The oral pleadings, like the written pleadings, consist of two rounds: the applicant state, then the respondent state, and then again. What is really different here is that where the parties may submit hundreds of pages, whether that's wise or not, there's no limit to how many pages of written pleadings they can submit. But the time is very short for oral pleadings. At most, you may have 2 days. That is 4 3-hour sessions, usually less than that in the first round. In the second round, you may have 1 half-day session of 3 hours or even less than that. So there is an imperative to be succinct, to be efficient, to emphasize the most important points, and to respond effectively to the main points that the other side is making. This can be very difficult, to take a large volume of written pleadings and then express yourself at the oral pleadings in what it amounts to a very brief amount of time. You have to be, you have to spend a lot of time determining what to say and what, reluctantly, you have to leave out because you only have a limited amount of time. Now, it is similar, though. How you construct your oral pleading does have quite a bit in common, although it's not entirely the same as how you construct your written pleading. Know your audience. You are pleading to convince the judges, not to convince yourself, your colleagues, or for that matter, your client. So you have to try to step outside yourself. Imagine how this is going to sound. Imagine how your pleading is going to sound, be understood, be appreciated, and be evaluated by the judges. Now, here is something the gentleman litigator from Japan raised, and I promised I would come to. And what is different about pleading before an international court? Well, I could cite quite a number of things, but I think that what, to me, makes it different is that my role is different. I envision my role differently. If I were arguing before a national court, say in the United States, I make the argument, of course, consistent with professional ethics and honesty. I make the argument that will best serve my client's interests. Even if I'm asking the court to do something that may put the court in an awkward position, or possibly even may get the judgment reversed by an appellate court. Consistent with honesty, integrity, and professional ethics, I'm less concerned about the impact of the ruling on the court and its institutional strength than I am about winning the case for my client. When I'm arguing before an international court like the ICJ, I have I cannot define my role the same way. We talked about some of this before. We are all elements, individual elements, all of us here and beyond, judges, professors, counsel, state officials. We're all part of a system that needs our reinforcement, any strength that we can give to this fragile structure. We all have a role, we all have a responsibility. When I appear before the International Court of Justice, or ITLOS, but mainly the ICJ because that's where I appear most, I approach it with a certain reverence. This is the guardian of the rule of law. This is the highest structure that we have in a fragile system. We have to respect that. We have to do what we can within the context of our effective representation of our client, always. But we have to act and argue in such a way as to be conscious of the need always to strengthen the institution, to lead the court, if we can, to a position which it can feel strengthened by. If we don't do that, then we are missing our calling. We're missing our calling as public international lawyers, and we're failing to carry out our responsibility, our personal and professional and moral responsibility to strengthen the system, even though what kind of strength can I contribute? But whatever I can do, it's my obligation to do. Now, balancing that with representing the interests of your clients is a certain challenge. But that's what we're doing. And it's important we explain this to the clients so that they know. This is their system more than it's mine. If I'm representing a state, this is their court. It's their system. Their interests, of course, are to win the case, but they're broader. Their interests are to strengthen the system too. So this is what makes it different. And I think I'm not unique in this regard. Many, if not most of all of us who practice regularly before the court treat it with a certain reverence, as we should. Now, in terms of some of the trade secrets, before I conclude, and I may go on for 5 more minutes. I could probably speak for 5 hours about this, but you don't want to hear me that long, and we don't have that much time. But credibility, again, honesty plus reliability. It's even more important in the oral pleadings. I mean, you're standing up there naked in front of the court. When you submit a brief, the lawyers don't sign it. It's basically anonymous. But when you are arguing before the court, of course, the credibility of your client is at stake, but so is yours. It's very personal because you're the one who they have to trust and believe, and you have to earn their trust. I'm going to tell you something that you expect me to say. Tell a good story. A good narrative. This comes from part 1 this morning. While maintaining strict accuracy, make it as interesting and compelling as possible. You have to maintain the judge's interest and attention over the entire length of your speech. Your goal is to make them feel that the time they spent listening to you was time well spent, because they heard something, or maybe more than something, that they considered helpful to them in understanding or deciding the case. And now, this is actually more difficult than maintaining the reader's or the judge's interest over the length of a written pleading, and I'll tell you why. When you're reading, you can read at your own pace. in a quiet place. A judge can stop and take a break when they get a little, let's say, tired, or to eat lunch, and they can resume reading at their convenience. If they come to something that's complicated or they don't quite understand, they can read it over again until they feel, okay, I understand this, they can move on. That doesn't happen during the oral pleadings. You have to maintain their interest, attention, and understanding one time through. You don't get to go back over, they don't get to see it again. Well, there's a written transcript, but you want them to get it the first time through. So you can't afford any rough patches. I go over and over my speech many times because sometimes I understand this very well. After all, I wrote it, I know what I mean. But stepping outside myself, will somebody who's listening to this, who hasn't been immersed in this one case for the last 2 years, find it easy to follow? If not, I refine it. I make it easier to understand, make sure that there are no rough patches. If you hit a rough patch in a speech and judges are confused, you not only lose the opportunity to persuade them with that part of your speech, but they may linger over it. They may spend 30 seconds trying to figure out what you just said, and the next 30 seconds of your speech is lost. So it's very important to go back over, simplify, clarify, make sure it's easy to understand, not just readable, but listenable, that it can be understood, is there a word, audially, as well as by sight. And that's different from a written pleading. Now, as with the written pleadings, clarity means short sentence, avoidance of jargon, unnecessary complexity, simplify as much as possible while maintaining technical accuracy. It will be easier to follow from beginning to end that way. Now, I'm sorry if I'm going on. There are just a couple of more points I want to, apart from the actual oral skills, there are some other techniques that are really, I think, vital to an effective oral pleading. One is the use of slides, projecting slides in front of the court. Sometimes a picture or a map or a photograph is, as they say, worth 1,000 words. And the judges get to see this for themselves and draw their own conclusions rather than using you as the medium and having to trust your interpretation of it. In fact, I like to do this not just with photographs or maps, pictures, but with the most critical evidence in the case, the most critical written evidence in the case. I feel it's one thing for me to explain the evidence or describe it to the judges, and of course, I strive to be 100% accurate. But it can make a stronger impact if you actually show the evidence to the court so they can see it for themselves with their own eyes, they can read it themselves, rather than to have to depend on you to receive it and interpret it, especially if you have powerful written evidence from documents. Or, as we did, I think I told you earlier, in the Palestine case, we had a series of slides with statements made by senior Israeli officials concerning the annexation, the sovereignty claims they were making with respect to the occupied territory. In the Georgia-Russia case, where we were trying to show the ethnic cleansing in South Ossetia, we had animated slides where we showed a depiction of, in South Ossetia, of all the Georgian villages and all of the Ossetian ethnic villages before Russia invaded. There were some that were mixed, but most of the villages were dominated by one ethnicity or the other. The Georgian villages were depicted in red, the Ossetian in black. Then we showed before and after. After the Russian invasion, all of the red villages disappeared. The effect, I think, was quite dramatic in demonstrating the effects of Russia's ethnic cleansing. And it was much more dramatic than our verbal description of it, to actually see the effects. Of course, these charts were based on reliable, authoritative UN reports. In the Nicaragua-Colombia case, where we were arguing for Nicaragua to show that Colombia was violating its maritime rights as determined by the court in a prior case, we had maps depicting the locations of Nicaraguan and Colombian vessels inside Nicaraguan waters. And then we played a tape recording and actually had the words running across the slide of the Colombian commanders telling the Nicaraguan ship they had to leave these waters because they belonged to Colombia or face forceful eviction. And when the Nicaraguan ship captain said, but the International Court of Justice ruled that these are our waters, the Colombian ship commanders responded, we don't care what the International Court of Justice said, we don't accept the judgment. This, of course, was all played out on the screen in front of the International Court of Justice, and I think it contributed to the judgment that we hope to achieve. Now, my time is up. I wish I could tell you more. I'd like to help you. Maybe there'll be another occasion to do that. But I want to give you one piece of advice that you must always remember. You must always remember this every time you go into a court. Keep your cell phone off. Or better yet, if you can force yourself to separate from it, don't bring it into the room, because it can happen to you. I remember one occasion when the cell phone went off. I'm going to check mine again just to make sure it's off here. Yeah. And cell phone went off. I don't know if President Donahue remembers this. I hope she doesn't, and I really feel silly reminding her, but for the sake of your benefit in the future, cell phone went off. I'm sitting at the council table. I'm looking around the room to who is this fool who left his or her cell phone on? You know, everybody is looking around, and then I realized it's coming from my briefcase. And I tried to be as discreet as I could in reaching down to it, down to my briefcase to turn it off before anybody realized it was mine, but at least one of the judges was scowling at me. So make sure you don't place yourself in a position where your cell phone, if that's the only thing you remember from these several hours of discussion from me, it will have been worth it. Well, it has certainly been worthwhile for me to meet you and address you and listen to you. I learned a lot from you. I really thank you for all of the very healthy and erudite participation of so many people. It's exactly what I had hoped for, and thank you for living up to the challenge. Thank you very much. Good luck to all of you, and I hope you enjoy the rest of this seminar, which is really a wonderfully organized seminar. And thank you very much to the Ministry of Foreign Affairs for inviting me and for putting on a seminar like this. I hope you'll do it every year, and I hope next year you will invite at least Ms. Goldich. And I didn't catch the name of our Pakistani friend or our friend from Iraq, but I think they would all make excellent speakers. So thank you very much.
Thank you, Mr. Reichler, for your very insightful and interactive lecture, including so many tips of advice to become a competent litigator or law practitioner. Once again, please join me in thanking him with a big round of applause.